Testing sound, equalizing sound, equalizing sound, equalizing sound, equalizing sound. Hey, my trendies, trendsetters, and my trendy tribe. I come with an update about Montez Holt, who most of you know is Martell Holt's brother. So I have to catch you up so then we can get into what he has pled guilty for. So I have 2 of the 3 warrants up because he did not plead guilty so far to what I have seen to possession of a pow pow. So these are the 2 of the 3 that he has pled guilty to. Okay, so this first warrant is a charge of possession of the Mary Jane, and the offense occurred August 31st, 2023, and he was arrested August 31st, 2023. It says charge 1, possession of Mary Jane, 1 count. It was a felon examination. And the warrant read, to any lawful officer of the state of Alabama, you are hereby commanded to arrest Montez Holt and bring him before the district court of Madison County to answer the state of Alabama on a charge of possession of Mary Jane, first class. Or I'm sorry. To any lawful officer of the state of Alabama, you are hereby commanded to arrest Montez Holt and bring him before the district court of Madison County to answer the state of Alabama on a charge of possession of Mary Jane. And it says the warrant was executed by arresting the defendant and placing defendant in the Madison County Jail. The second warrant, it says defendant was arrested on August 8th, 2023. This bond was set at $200,000. Felon examination was supposed to happen and was a charge of trafficking. I'm going to say mathematics. I don't see it on here, but when you see his plea, apparently there's also some Fenty Fen that was there as well, at least for what he was charged with. And so this warrant said, to any lawful officer of the state of Alabama, you are hereby commanded to arrest Montez DeJuan Holt and bring him before the district court of Madison County to answer the state of Alabama on a charge of trafficking mathematics. And you can see this is very different from his bond amount. That was, I believe, $1,000 on the Mary Jane, because this one is $200,000. And just to look back, yes, the other bond was $1,000. So on July 18th, Montez entered an application to plead guilty. It says, comes the defendant in the above styled cause and informs the court that the defendant was arrested for the offense of POMJ, which I had to deduce was possession of Mary Jane, conspiracy to traffic mathematics, and Fetty Wap. Read between the lines for Fetty Wap. It says he has been bound over to the circuit court to await action of the grand jury, is confined in jail awaiting a preliminary hearing, or is confined in jail having waived presentation to the grand jury. Desires to plead guilty in this case is represented by Bruce Gardner, and it says is charged with conspiracy to traffic mathematics and Fetty Wap and possession of Mary Jane, which is a non-capital felony offense. Wherefore, after obtaining the advice of counsel, defendant asks that the court take jurisdiction of this cause and direct the DA of this circuit to prefer and file an information against the defendant under the provisions of Section 15-15-20.1 Alabama Code 1975, and signed by Montez Holt, July 18th, 2024. The court issued their first order regarding his plea of guilty. And so the court says the defendant in the above styled cause, having petitioned this court to be allowed to plead guilty to possession of Mary Jane in the first degree, a non-capital felony offense, pursuant to section 15-15-20.1 Alabama Code 1975, and the court having considered the same, the court finds that the defendant desires to enter a plea of guilty in this cause and waives indictment. Defense counsel shall, within 7 days of the date of this order, contact the assistant district attorney assigned to the case and discuss settlement. Defense counsel shall then notify the court in writing by placing a copy in Judge Mann's courthouse box that an agreement has been reached, in what facility the defendant is located, and if they are at risk of being transported by the Alabama Department of Corrections before an arraignment date can be set. Once all signed paperwork is received by the court will promptly set the case to enable the defendant to formally enter a plea of guilty in open court to the charged offense. If the plea agreement includes an agreement to null pro se additional cases, or it might be null pros, the case will not be set until said motion is received by the court. It is the responsibility of defense counsel to ensure this requirement is met. And for my fellow people with a non-legal background, null pros is a Latin phrase which directly translates to not to wish to prosecute. It's a legal notice or entry of record that the prosecutor or plaintiff has decided to abandon the prosecution or lawsuit. So rereading the sentence, it says if the plea agreement includes an agreement to null pros, meaning prosecution has decided not to prosecute, the case will not be set until said motion is received by the court. If the court does not receive confirmation of a plea agreement pursuant to the directive set out herein within 14 days of the date of defendant's application, said application will be denied. Upon the setting of an arraignment date by the court, the DA is ordered to immediately prepare and file an information setting out the offense for which the defendant is charged with the same certainty as an indictment. Done this 24th day of July, 2024. Okay, Trendies, you already know what I'm going to ask. Let me know your thoughts in the comments section, and I will talk to y'all later. Bye.